So with this experience you've had in cooperative movement,
Yes.
I mean cooperative tribunal, I'm seeking to know from you what tactics you would apply, because if you were to become a High Court judge, you could probably land either in, family division or commercial division. Of course, there are also other divisions, but I'm seeking now to understand the tactics that you deploy to achieve the same impact in the cooperative tribunal.
Thank you very much. I had mentioned earlier that we have managed to reduce the trial cycle of cases. By that, I mean that when we are doing the Order 11, we also look at the overriding objectives under Section 3 of the Civil Procedure. We make sure that we are not bound by technicalities. Number 2, for the simple matters, we go ahead and enter summary judgment, or just tell the parties to file their submissions within a limited time. Number 3, we have also managed to reduce the litigation cycle. By reduction of litigation cycle means that we do away with all unnecessary interlocutory applications, of course ensuring that the subject matter is preserved. I always persuade the advocates. Now at the tribunal, we are not we use the cooperative tribunal practice and procedure rules, which indicate that the chairperson and the deputy chairperson can make any decision in regard to the delivery of justice. In the High Court, I will be able to persuade the advocates to put aside or to suspend all the applications that are pending so that we can go to the merits of the case, and that will ensure that matters are heard and finalized on merits. Thank you very much.
Yes, thank you. I will take you now to the Constitution of Kenya, which guarantees independence of the judiciary. Yet we are still struggling to assert that independence. Give me 3 reasons why that is the case.
Thank you, Honorable Chief Justice. Judiciary has the authority to handle matters, and this authority has been given by the Kenyan people. In exercising this judicial authority, the independence of the judiciary is very critical, because the judiciary is the one which enforces the rule of law and ensures that there is fair trial. The reason why we are struggling with judicial independence and what we can do about it is, number 1, we need to have judicial education. By judicial education, we need to empower our judges, our judicial officers, and our judicial staff to ensure that they are competent, professional, and very ethical. Once the employees of the judiciary are competent, it is automatic that the members of public will have confidence in the institution as a whole. Number 2, we also need the judiciary the independence of the judiciary also needs to be in collaboration with the other arms of government, because the judiciary is just one arm, and in dealing we need the executive, we need the legislature in terms of providing the resources, in terms of policy making, but the judiciary should not be at the direction of anybody in making its decisions, but on issues of framing of policy, the judiciary should act in tandem with the other parties. Then the judiciary also should, in terms of independence, has to have decisional independence in terms of the people that the judiciary employs and brings on board. Thank you very much.
Yes, I've heard you. I think you will have to refresh on that. The reasons why we are struggling with the independence, asserting the independence of the judiciary. The High Court is said to be the most impactful in the scheme of justice in this country. I want you to give me 5 areas of jurisdictions that make the High Court the most impactful.
Yes, the High Court exercises original jurisdiction in civil and criminal cases. It also exercises jurisdiction in constitution matters in terms of human rights. It is also an appellate court. It also handles matters in regard to relation of government and national government and the county government. Number 5, it also does criminal revisions, and it also exercises supervisory jurisdiction over the subordinate courts and tribunals.
Thank you. I can do with that. Now, there are circumstances that we apply international law. Can you tell us at least 4 of those international laws that are applied here in Kenya, and under what scheme of our law are they applicable?
Yes, under Article 2, Article 2 of the Constitution, the international laws are part of our laws and since they have been domesticated. We have the sorry, I want to clarify whether I need to state the international law and how it is applicable.
Yes.
Okay,
you have said they have been domesticated. Yes. So if you can tell me those ones which have been domesticated.
Yes, for example, the International Arbitration Act, it is domesticated in terms of the High Court has jurisdiction in adopting and enforcing their awards. We have the United Nations Children Rights. We have the UNHCR, United Nations Human Rights Commission. We have the UN Convention.
That's the UN Convention. Which is the domestication of the International Human Rights Convention.
We have the Kenya National Human Rights Commission Act, which is also in the provision is in the Constitution. We have the International Children Rights Act. We have the Children's Act in Kenya.
I think it's okay. Judge Majanja.
Yes, Maputo Protocol, I have heard of it. It is about the women's rights.
What about it?
That the women rights are protected under that protocol, and it is domesticated in Kenya under Article 2. Yes, I am an executive committee member of International Women Association of Judges.
You have not been oriented with the Maputo Protocol?
Wow, it has been long since I dealt with issues of women and children's rights.
Okay.
Yes.
But now you want to be a High Court judge, eh?
Yes.
Tell me, when you are confirming a grant, if you are confirming a grant, what are 3 things you would look out for when parties come before you and you're confirming a grant?
In terms of documentation or in terms,
in terms of documentation, in terms of legal requirements, what would you look out for in confirmation of a grant?
First of all, before you get the grant confirmed, you have to get a letter from the chief confirming the beneficiaries of the parties.
The grant has been issued. Now you are on confirmation.
Confirming, ensuring that all the beneficiaries are entitled to to inherit from the deceased, ensuring that there is a grant and there is an administrator, ensuring that all the assets of the deceased have been named and they are in the grant.
Okay, I will need to refresh your mind on that. Now you are in Kitui as the High Court judge, and in the morning when you open your newspaper you read that the court in Mutomo sentenced a woman for stealing a chicken to 4 years imprisonment. What would you do?
As the High Court judge, I would be in supervision of Mutomo Law Courts, which is a subordinate court. I would call the file for revision of the sentence.
So you've gotten the file, you find she pleaded guilty. What would you do?
In that instance, when a person pleads guilty, then the High Court is, as a judge, I would only be entitled to revision of the sentence.
So what options are available at that point?
I can either review the sentence and release her on CSO or probation, or give her a fine, because I believe that that sentence is very harsh in the circumstances.
Okay, thank you.
Your Honor, Madam Kimemia, I have a few questions for you. Sorry, but before we go into that, I saw that in your bio, you stated that you are a person with disability.
Yes, that is the correct position.
Okay. Would it be inappropriate to talk about it?
No.
Because when you walked in, you looked very okay to me.
Okay, disability can, I believe that disability should not manifest physically for everybody to see, but I have a disability on the right hand. It is a congenital branchial plexus injury. It happened at birth. They pulled and messed up with the nerves and the muscles.
Which hand?
The right hand.
So it affects your writing?
It affects the burden on the left hand, but I am much capable, and it does not affect
you are
my
right-handed?
work. I am left-handed.
Left-handed?
Yes.
Oh, okay. All the best.
Thank you.
Yeah. Now, I've read your your judgments in the sample writings. Your judgments at the courts in Kitui and elsewhere, and also your decisions, your judgments in the tribunal, cooperative tribunal. I think they are well written, clear, well arranged, and structured.
Thank you.
Now, preparing to come to the High Court, and intending to come here where the core job will be judgment writing and determination in cases, how different do you think it will be? The judgments you have been handling, which are quite long, thorough, and clear, and well reasoned in the tribunal, how different will they be from judgments in the High Court? And now remember,
yes,
in tribunal you have done very well, but it was a collegial tribunal where there were several members, and I saw that there are other lawyers who are members of that tribunal.
Thank you very much. Despite the fact that the tribunal is collegial, we only discuss and deliberate on the issues, and thereafter the file is allocated to one of the persons to write. In the High Court, I believe there will be legal researchers, but at the end of the day, my writing, my clarity, my judgment, writing skills will not be affected. And I believe I will even do a better and more thorough job, because there are more resources at the High Court in terms of research. Thank you very much.
Okay. Now, you in the tribunal, that's where I've been seeing most of your sample writings have come from. You did not leave out authorities, they were set out very well. But ultimately, in terms of jurisprudence, where do you think your passion is? Which area of subject? Constitutional, civil, commercial? You've done very well in these commercial matters.
I have grown up through the ranks as a magistrate, and as a magistrate we have had no choice in terms of specialization. So I am broad-winded. I will fit anywhere I am posted. Thank you very much.
Okay, I didn't see a lot of questions of disputes on jurisdiction to the tribunal. In the High Court, there will be many issues. The issue of jurisdiction will come in. as a matter of preliminary points of law. How do you intend to handle them?
In the tribunal also there are issues of preliminary objections in terms of jurisdiction, especially when parties sometimes feel that the cooperative tribunal should not be dealing with land matters. And we write those rulings to clarify that the cooperative tribunal deals with all the business of the cooperative societies. In terms of dealing with POs at the High Court, I will let the parties file their responses and file submissions, and thereafter sit down and write on the ruling on the issue of jurisdiction.
Okay. Lastly, because my interest was in the area of writings, and you are doing an LLB, sorry, a master's course at the moment.
I have finished. I graduated in December 2023 last year.
Oh, so you've got an LLM?
Yes, I have
I
an
missed
LLM.
out that.
The
Okay,
certificate is with the documents.
Okay, sorry. Thank you for that. You seem to have started another master's program at USIU in 2001.
Yes.
Why did you abandon it?
Well, at that time, I had a challenge with finances. It was also the time that I was doing a Kenya School of Law, and during pupillage, you are not given any remuneration. The implications of now becoming an advocate and digging in with the master's degree was also an issue. Yeah. But I finished the coursework, I finished the thesis, but I had an issue with my supervisor.
Okay, thank you. I wish you all the best.
Thank you very much.
Thank you, Chair. Good afternoon once again, Your Honor.
Good afternoon.
I have a series of questions for you. On two occasions, okay, one is when there was an issue between yourself and Honorable Mwenda. It was brought to our attention, it was resolved. Again, there was an issue between yourself and the deputy tribunal chair, vice chair members. Again, it was brought to our attention, it was resolved. So what does that tell us about you as an individual? Or any lessons learned, maybe after the engagement and peer support?
It is true when people are working together, they have differences of opinions. However, I wish to state that I am not aware of the issue with my deputy. It was not brought to my attention, but we work very well together. Mm-hmm. In terms of reconciliation and also getting back together, I believe I have learned that it's good to be a team player, and it is good to submit to your seniors and to for peer review. And once you are corrected, then you resolve the issues and continue working together. I have learned that it is very important to be a team player, and even as a team leader, all the opinions of everybody matters. Therefore, it is also good to listen to every individual.
Okay. So, yeah, thank you for that response. And the other issue, there are concerns that within the cooperative tribunal there are camps. One, the chair's camp, the other, the vice chair's camp. Is it a perception, or in terms of people preferring to work with the chair only, people preferring to work with the vice chair, so it doesn't then build collegiality amongst members?
For the members, we are all collegial. Maybe the issue was with the members of staff who are engaging with outer issues which were not within their premises, and because I am a strict person and I adhere to the policies, sometimes it is easier for members of staff maybe to go to a person who is more lenient. I'm a seasoned judicial officer and I know the cracks to look for, especially with the members of staff, and maybe they were trying to take advantage of the busy schedules between the chair and the deputy, but I believe it was perceived camps. Mm-hmm. I have always worked well with my members. I believe there is no complaint from my members.
The perceived camps, has that issue been resolved?
There is no camp at the moment. It was resolved when the members of staff who had stayed long in the tribunal and felt that they had some certain privileges were transferred to other tribunals for having overstayed.
Okay, and how would you describe the uptake of e-system within the tribunal, the cooperative tribunal?
The uptake is quite good. We do all the directions, all the mentions virtually. We also handle hearings virtually, but some cases are quite complex that doing them virtually would be very, very difficult, especially due to documentation, the values of the matters, and sometimes even advocates prefer to come to be heard physically. We also do circuit courts. Circuit courts, we take justice to the people, especially to the person. Like if you go to Kisumu, there are people who are not able to afford internet. They don't have smartphones. One time I was at Kisumu.
Okay, but that's okay. I just wanted to confirm, because there is also concerns from stakeholders that cooperative tribunal is among the tribunals that is resisting the e-system. So that's why I wanted to know the uptake. You've said you do directions because of the complex matters, you prefer physical. Have you shared that communication with the Office of the CRG or Office of the CJ? Because if the Supreme Court, the Court of Appeal, High Court, ELC courts that have also very complex cases are able to do virtual hearings, why aren't you able to do that, the 100% or even like 80% uptake of e-system?
The only issue is the hearings. All the other uptake on ICT is up to point. We do certificates online, we do applications online, submissions are filed online, except now
Hearings,
for...
I'm concerned about the hearings.
The hearings, sometimes the parties don't have stable internet accessibility. Sometimes you're in the middle of the matter and the calls drop and the advocates actually choose. Before we fix a matter for hearing, we tell the advocates to decide to let us know what their option is, depending on the complexity of the matter, whether they want to be heard physically or virtually. And we are obliged to the choice of the advocate.
But you can confirm to the Commission that most of your matters, the hearings are done in person.
Yes, but we have not resisted.
Have you shared that issue? Because I know the other tribunals that have taken e-systems 100%, including the tax tribunal. And even them, they have complex issues. So if you're facing any problem, I think it would be prudent for you to engage the Office of the CRJ to see how that can be addressed. And lastly, the tribunal bill that is before Parliament, what is your thoughts around it? Should the cooperative tribunal remain with the ministry, or it should come to JSC? Your thoughts, your personal thoughts.
My personal thoughts is that all the tribunals must and should be in the judiciary, because they deal with quasi-judicial matters, and under Article 159D, it is the proper place for the tribunals to be. The bill indicates that the cooperative tribunal should be under the judiciary, under the JSC, and the JSC should appoint members on merits. I fully agree to the proposals
and
in the
bill. And in terms
bill.
of the memo to Parliament with regards to this particular bill, are you aware of any memo that has been submitted to Parliament that gives contrary opinion as to where the cooperative tribunal should be?
I am aware that my members sat down and deliberated, and that is the opinion of the members. I am not. I am not getting out of the fact that this was a memo presented by the cooperative tribunal, but at the end of the day, each and every member has their own opinion.
Where you chair, the members, you chair the membership.
I chair the membership.
Okay, thank you. Wishing you the very best.
Thank you very much.
Thank you, Honorable Chair. I think I have only one question for you, because you have alluded to some of the questions that I would have asked you when you were answering Commissioner Ngutia's questions. Now, the judiciary has been implementing a transformation agenda since 2010.
you've seen where the judiciary was before the promulgation of the Constitution and where we are now. Would you share with this panel what your contributions will be should you become a judge towards the realization of this journey?
Since the promulgation of the Constitution in 2010, we have had a journey with the transformation framework. We had the judiciary transformation, judiciary transformation framework. We had the sustaining judiciary framework, and now we have the sustaining judiciary transformation through, social transformation through access to justice. My contribution in the High Court would be in terms of ensuring that there is expeditious disposal of matters, that there is access of justice to the parties, that there is increased partnership with the stakeholders, that there is increased public trust, and that I will take up ICT as a justice enabler.
Thank you, my lady. Good afternoon once again.
Good afternoon, Honorable Commissioner.
Yes, I'll be very quick. I have your report from DPOP. It's a good report.
Thank you, Honorable Commissioner.
You seem to be doing a good job at the Cooperatives Tribunal. I'm looking at your court productivity, higher than the national average, which is very good. You are the chair.
Yes, I'm the chairperson.
So are you also in charge of administration?
I am the head of station.
You are sort of like the head of station.
Yes.
So other than the judicial work that you do other...
Yes, I also supervise the members of staff and the members of the tribunal and the deputy chairperson.
Okay, you seem to be doing a good job, because even with that added responsibility, you're putting in more than is expected of you in terms of the output of the station. What is expected of you is 50%. You're doing 68%, which is wonderful. Your general performance is at 136%. The area of concern is your case clearance rate. You seem to be creating backlog at the rate of 17%. Your case clearance rate is 83. The national average is 110 for the tribunals. I don't know what challenges you may be experiencing in terms of case clearance, and what are the interventions you are putting in place as we speak now.
In the nature of the cooperative tribunal, we sit as a bench, and the quorum is 3. Sometimes there is a challenge in the issue of membership, especially like right now. I have been presiding the cooperative tribunal since December, because I do not have a deputy chairperson. She has not been gazetted, she has not been sworn in, and that has brought up a lot of challenges, especially in terms of quorum. When there's a quorum hitch, then there's an issue of not hearing matters expeditiously, because now I cannot, as much as I would like to sit alone, I cannot sit alone because of the jurisdictional issues. Thank you very much.
Okay, the second question I want to ask you concerns, still on the subject of case management, the multi-door approach to justice. How do you see your role as a judge in promoting the multi-door approach to justice?
Thank you very much. The multi-door approach to justice is moving away from mostly formal resolution of disputes to enhancing or embracing the informal modes of case resolution, and this includes mediation, reconciliation, alternative justice system. And as my role as a judge is to ensure that parties try to reconcile their issues either before they have filed the cases or after they have filed the cases. I do it all the time in the cooperative tribunal, because noting that in cooperative societies, the members are from the same area or from the same workplace, and it is always good to make sure that they don't come to court and fight and ruin all their relationships. So sometimes, or most of the time, I tell them, sit down, try and reconcile. If you owe A, B, C their money, please have an arrangement on how you're going to settle the matter. And we have resolved quite many matters on consents parties have withdrawn, and that is what I wish to bring also to the High Court, ensuring that parties have alternatives to the formal.
So that is one way. Any other way you can think of? One way is, of course, to encourage parties to explore the possibilities of using other avenues to resolve their disputes. Is there any other way you can think of? You can promote multi-door approach as a judge.
Yes, also sending parties to court annexed mediation.
That is reference still.
Okay. I think I will look up on that.
Oh, okay. Thank you very much, and I wish you well. Thank you, my lady.
Yes, thank you very much, Madam. You've answered most of the questions. I don't have a lot, but I just want to know, now that you've led the tribunal, you've been Chief Magistrate, now I'd like you to tell us some of the key achievements that you've had as a leader, that is the specific achievements that can be attributed to you as a leader and your leadership excellence.
Thank you very much, Honorable Commissioner. My key achievements at the Cooperative Tribunal, I have cleared backlog over 6,000 cases. We have received and we have been recognized as the best tribunal for the financial year 2019, 2020, 2020, 2021. I believe that goes much to say about my working methods and the issue of clearing of backlog. I manage members of staff. I manage members of the tribunal. I sit as a presiding officer during the hearing of the cases, and therefore I am involved in giving leadership specifically to the members and during the hearing of the matters before the tribunal, and ensuring that judgments are written, ensuring that they are delivered. I have also ensured that there is transparency in decision making, such that when a matter is complete, we sit down as the bench which had the matter, we deliberate on the matter, and then we make a decision, and one person writes the judgment or the ruling. In other instances, apart from the transparency, we ensure that there is consistency in the decisions that we have made in the tribunal. I have also contributed to the jurisprudence of the Cooperative Tribunal. If you go to the Kenya law reports, you'll find that most of the decisions that we have made are uploaded within 7 days of delivery. As a tribunal of appellate jurisdiction, we have also handled matters that are appeals from the surcharge orders of the commissioner. Apart from that, we do leaders meeting. When we go for circuit, we make courtesy calls to the cooperative offices for purposes of keeping up and letting them know that we are there and resolving any issues that they may have. As a leader, generally, I'm a person of integrity. I'm a person who takes my work very seriously. I am accountable to the members of public, and I believe I have given service in this institution and to the members of public for the past 18 years, and I believe that given this opportunity, I will continue to be of service in accountability to the people of Kenya who have given us the authority to exercise this judicial power. Thank you.
Okay, thank you. Wish you well.
Thank you very much.
Thank you, CJ.
Thank you, Honorable CJ. Honorable Kimemia, when you talk about Mutomo, Zombe, Endau, those are areas I'm very conversant with, and I know the challenges that you must have been going through, especially when there was no road. So good job for doing your best despite the challenges.
Thank you very much.
Yeah, so to my questions, you've mentioned that you're a person of integrity.
Yes.
And I am sure with your many years of experience, you must have gone through an experience that your integrity was put to test. Please tell us about it and how you went about it.
Thank you very much, Honorable Commissioner. Integrity means that as a judicial officer or as a judge, you should be above reproach and ensuring that justice is not only done but also seen to be done. An example is at one time we were having deliberations with the members at the boardroom, and a CEO of a cooperative society whose members have been filing so many cases for refunds decided to just come and enter the boardroom and said that he wanted to have audience with the chairperson and the members of the tribunal. So we listened to him, but what he was asking is that he was asking that we would slow down on the issue of giving judgments. For refunds from the cooperative societies for the members, we do reduced trial cycle such that parties only file submissions, especially when they have no liabilities attached to their savings. So because the cooperative society was going down and members were exiting very fast, they were having a problem in refunding and the number of judgments that were coming from the tribunal. So we listened to this CEO, but at the end of the day, we told him that it was not the right forum. We have to do our work. And the next time, he should make sure that he follows the procedure of ensuring that he writes a letter. If he writes a letter, then we will know what the purpose of his visit is. But at the end of the day, we told him that we cannot do what he was asking us to do because we are here to deliver justice to everybody in the cooperative society movement. Thereafter, I asked the member of staff who had ushered in the CEO why they had brought him to the meeting at the boardroom, and they said that the CEO had insisted and there is nothing they could have done about it. Therefore, I told the members of staff the proper procedure to follow in case anybody wants to see the chairperson or the members of the tribunal. Thank you.
Would you have handled that CEO differently if they approached you in your office separately?
No, I would not have handled it differently.
Okay. All right. My final question. The Constitution of Kenya assumes the theme of good leadership and integrity throughout its chapters, and we also have other acts that address the issue of integrity. Maybe you could give us about four sections in the Constitution or any other acts that talk about leadership and integrity.
Oh, leadership and integrity. We have Article 73, which is Chapter 6. It talks about leadership and integrity. There's an article for public service. Yes, Article 73 and 74 and 75, and then there is also the integrity of the judiciary and Article 159.
Article 159. Okay, I'll check that. Thank you.
Thank you.
Thank you very much, Honorable Kimemia, for availing yourself for this interview, and thank you, commissioners, for a very engaging session this afternoon. I think this brings us to the end of the interview, but we always give a candidate an opportunity to ask a question if they have any for the commissioners.
Thank you very much, Honorable Chief Justice. I don't have a question, but I wish to say thank you for giving me the time to appear before you and giving me the opportunity to irate myself in terms of this application for the position of judge. As much as I'm a person with a disability, I believe that it has not affected my work. and I have risen through the ranks of a resident magistrate all the way to a chief magistrate. And even as you look at my application, I pray that God will be with you. Thank you for giving me the opportunity, and thank you for giving your service to the people of Kenya. Thank you very much.
Yes, on behalf of the Commission, I wish you well and encourage you to continue working hard. We will get in touch with you when we complete the exercise. All the best, and our greetings to the cooperators.
Thank you very much, Honorable Chief Justice and
Yes.
Honorable Commissioners. Have a good afternoon. May God bless you.